Welcome to the Montana Human Rights Bureau's presentation on reasonable accommodation for disabilities in the area of employment. One of the hallmarks of disability discrimination laws is the requirement that covered entities provide reasonable accommodations or reasonable modifications. Regarding covered entities, typically the Americans with Disabilities Act applies to employers with 15 or more employees, while the Montana Human Rights Act applies to employers with 1 or more employees. Most discrimination laws are written prescriptively. They instruct you not to treat people differently because of protected class. However, there are a couple places where employers have an affirmative duty to do something in order to be in compliance with the law. One of those places is reasonable accommodations. By law, persons with disabilities are entitled to reasonable accommodations that provide modifications to how things are done in the workplace so that they have access. Reasonable accommodations are just that, reasonable, and ultimately they are good business. Persons with disabilities are part of our diverse workforce, and we need to make sure they have the tools or means to be successful. Here we see the initial analysis that the Bureau goes through when it receives a complaint for filing that an employer did not provide an employee a reasonable accommodation for a disability. This is a failure to accommodate analysis. The basic elements are that the charging party is a person with a disability who requested an accommodation, and the respondent failed to provide an effective accommodation for the disability. But within the examination of these three elements are a lot of moving parts and considerations that make up the party's responsibilities regarding reasonable accommodations for disabilities. Think of it as a process. So, what triggers that process? How do you know when you have to provide such an accommodation? The first thing that triggers that process is when a request for an accommodation is made. The second thing that could trigger the process is knowledge an employee has a disability that requires an accommodation to perform the essential functions of the job and is unable to put forth a request due to the disability. Two examples of when an employee is unable to put forth a request due to disability is if an employee is in an accident that results in the employee being in a comatose state, or when an employee experiences a cognitive disability that makes them unaware of their rights or obligations under the law. There was a case where an employer terminated an employee for no call, no showing after she fell off a horse and was in the hospital with a brain bleed. Since the employer was aware of the circumstances, the employer was obligated to provide an accommodation to the employee since she was unable to request one due to disability. There is no requirement for magic words. A person does not have to use the words disability or accommodation. The employee only needs to give you enough information to put you on notice that they need some type of modification at work due to a medical condition. Not only can the employee use plain English to make such a request, but a request can be very informal as well. Basically, if you have an employee that brings up a medical condition or impairment, expressly or implicitly, and then he or she talks about how this is impacting their work in some manner, your best bet is to consider this type of statement a request for accommodation. Unfortunately, a lot of employers tune out these types of conversations or requests, and it creates some trouble down the road. Employers should also take note that someone other than the employee can make a request, such as an advocate or a spouse. There are no time restrictions to asking for an accommodation either. An employee can request an accommodation upon being hired or at any time during employment. Additionally, applicants for a job position can request reasonable accommodations as well. Also, if an employer has a form for employees to fill out in order to request an accommodation, please remember that an employer cannot ignore an oral request that was made even if the employee does not follow through with turning in the initial form. The Bureau recently had a case where an employee informed his supervisor that he was experiencing what he called gut issues, and he kept calling out sick. He would check in with his supervisor quite frequently to call out or let her know when he was going to the doctor, but after 3 weeks he was fired for job abandonment. This case went cause because the employee's notice of a gut issue to the employer and his request for time off was sufficient to constitute a request for accommodation. The employer did not recognize it that way. So on the heels of that example, let's go over some more examples to explore what is and is not a request for accommodation. There is no way that I can finish these reports by Friday. No, this is not a request for accommodation. While the employee is making a statement regarding their ability to finish what may be an essential job function, there is nothing in the statement that connects the employee's inability to finish the reports with a medical condition. I've started a new medication and I'm not going to be able to come into work at 8 anymore. Yes, this is a request for an accommodation, assuming the employee is making this statement to a supervisor or someone in management. The employee's statement about a new medication implies that the employee has a medical condition necessitating medication. So the employee is implying that a medical condition is impacting his or her ability to arrive at work at 8 a.m. This type of statement is a request for an accommodation that might necessitate a modification to policy regarding what time the employee must arrive at work to be on time. I totally want that $769 chair that Mike has in his office. No, this is not a request for a reasonable accommodation for a disability. I'm sure everyone in the office would love to have Mike's expensive chair. While the statement is making a request, that request is not tied in any way to a medical condition or impairment. The new phones are not working with my hearing aid. Yes, this statement is a request for a reasonable accommodation. Again, assuming the statement is being made to a superior, the employee is putting the employer on notice that they have a hearing impairment necessitating a hearing aid and that that impairment is impacting his or her ability to use a piece of office equipment. I'm super tired. Can I go home? No, this is not a request for reasonable accommodation. I'm sure a lot of people have requested time off because they are tired. However, an individual expressing he or she is tired does not suggest that individual experiences a medical condition or impairment. But remember, context is king. So for example, if you have an employee that you know has epilepsy and that employee experiences a seizure at work and right afterwards makes this statement to you, in that context, such a statement would be a request for accommodation for disability. So now that you know how to identify a request for accommodation, what do you do with such request? The answer is what's called the interactive process. Both the employer and employee who is requesting an accommodation have a duty to engage in the interactive process. Once you recognize a request for an accommodation, you should begin the interactive process as soon as possible. Having a good, clear policy that meets the needs of your business in these situations is going to be your best guide in how to engage in the interactive process. If you're looking for some policy ideas, you can see how the state's Human Resources Division handles reasonable accommodations online in the Montana Administrative Rules. It's ARM 2.21.41. The establishment and implementation of policies are imperative. However, remember that every interactive process you engage in as an employer will likely be different. These are case-by-case situations with varying complexity. Some interactive processes will be very easy with a simple accommodation identified and put into action rapidly. Others can take days and require multiple meetings and gathering of information to be reviewed in order to determine an effective accommodation. So keep that in mind. A question that often comes up is if attorneys need to get involved. The short answer is no. Perhaps if there is ongoing litigation, it could be helpful to consult your attorney, but generally you do not need to be represented to engage in the interactive process. However, it would be a good idea to document the process. Take really good notes, draft memos, and send emails of what's happening. When all is said and done, know who is going to do what when you're walking out the door after a meeting for an interactive process. The keys are to engage in the process in a timely manner and in good faith while maintaining positivity. Here are some important points to remember regarding the interactive process. The interactive process requires communication and good faith exploration of possible accommodations between employers and individual employees. The shared goal is to identify an accommodation that allows the employee to perform the job effectively. Both sides must communicate directly and exchange essential information. Neither side can delay or obstruct the process. When a party obstructs or delays the interactive process, that party is not acting in good faith. Remember, good faith is a requirement when engaging in the interactive process. not tepid faith, and not passive-aggressive faith. So if you're a manager or supervisor with a request for disability accommodation in front of you, check your emotions and preconceptions about abilities and disabilities, and don't bury your head in the sand thinking the request will go away. There are 5 basic steps you will want to make sure you cover when engaging in the interactive process. Remember, the shared goal of an employer and employee engaging in the interactive process is to find an accommodation for a disability that will effectively remove a workplace barrier that the employee experiences due to a disability. These steps apply whether you have an employee asking for time off for cancer treatment, remote work due to an underlying condition that could be exacerbated by COVID-19, or a need for modification to a computer screen due to a visual disability. Of course, if you have an employee asking for an accommodation or modification to enjoy the benefits of the work environment as other employees do, such as access to a break room or Christmas parties in an accessible location, a review of the job description and discussion of job limitations may not be applicable to identifying an appropriate, reasonable accommodation. But in most other circumstances, the basic steps are: first, analyze the particular job; second, consult the individual with a disability to ascertain the precise job-related limitations imposed by that individual's disability; third, identify potential accommodations and assess the effectiveness; fourth, implement the accommodation; and fifth, monitor the accommodation. Next, we are going to review each of these steps in a little more detail. When trying to determine an appropriate, reasonable accommodation for a disabled employee, or assess an accommodation proposed by an employee with a disability, the first common sense approach under most circumstances will be to analyze the employee's job. This includes a review of the job description and identifying the essential functions of the job. Not only will this review help the parties to understand and identify potential accommodations better, but it is also important because an employer is not obligated to reallocate or remove essential job duties as an accommodation. An employer can choose to do so, but there is no legal obligation. Job restructuring includes the redistributing of marginal functions or an altering of when or how an essential or marginal job function is performed. If an employer offers a job restructuring as a reasonable accommodation that eliminates some marginal functions of a job, the employer may require the employee to take on other replacement marginal functions that they are capable of performing with their disability. Some of the factors in differentiating an essential function from a marginal function include the employer's judgment of which functions are essential, the amount of time spent on job performing the function, the consequences of the employee not performing the function, the terms of the collective bargaining agreements that may exist, the work experience of past employees in the job, and the current work experience of employees in similar jobs. The next step, after analyzing the employee's job, is to talk to the employee. An employer should engage in dialogue with the employee about the implications of his or her disability on the essential functions of the job. Since an employer is obligated to provide an effective accommodation, it behooves the employer to understand the barrier experienced by the employee at work due to disability. Some questions that may come up in this type of dialogue include: how does the disability affect job performance? Is the condition progressive, stable, or unpredictable? What specific job tasks, work environments, equipment, or policies are creating barriers to a successful job performance? And is there documentation to support the condition and need for accommodation? Let's quickly address the issue of evidence to support the employee's need for an accommodation. Employers often call the Bureau when they get a disability accommodation request, and one of their concerns is a doubt that the employee is even a person with a disability. If that's the case, that an impairment is not obvious, then the interactive process is your tool as an employer to verify the employee's status as a person with a disability and need for an accommodation. However, an employer is only entitled to reasonable documentation, documentation that establishes a person has a disability and the disability necessitates a reasonable accommodation. Requesting an accommodation does not give you the right as an employer to know someone's entire medical history. Instead, you must stay focused on figuring out whether someone has a condition or impairment that substantially limits a major life activity and how and why they need the accommodation to address this condition or impairment in order to perform an essential function or access benefits. If a person has more than one disability, an employer can only ask for information pertaining to the disability at issue in the accommodation request. An employer may require the documentation about the disability and functional limitations come from an appropriate medical provider. The appropriateness will depend on the disability and type of limitation, but can include doctors, psychiatrists, psychologists, nurses, physical therapists, occupational therapists, speech therapists, vocational rehab specialists, and licensed mental health professionals. An employer can ask an employee to sign a limited release to allow an employer to submit a list of specific questions to a medical professional addressing the existence of a disability, its functional limitations, and the need for reasonable accommodation. Also, be mindful of the time and cost associated with obtaining medical information. Do not ask someone for medical verification if they've provided sufficient medical information already, or if the impairment is obvious. If you're concerned about the veracity or viability of the medical information provided, an employer can require an employee to visit a healthcare professional of its choosing and at its own cost, but tread lightly. Beware of the battle of the medical experts. Keep all medical inquiries job-related and consistent with business necessity. Ultimately, if an employer refuses to provide documentation and the disability is not obvious, the employee is not participating in good faith and is not entitled to a reasonable accommodation. On the other hand, if an employer has information that a reasonable person would believe is sufficient to document the disability and need for an accommodation, and the employer refuses to move forward on the request, the employer could be liable for failure to provide a reasonable accommodation. Here at the Bureau, we have seen cases where charging parties go to their employer with specific accommodation requests. They feel they've already identified what accommodation would assist them in the workplace. We also have had cases where a charging party is more uncertain but knows they are experiencing a work issue due to disability, but they don't know right offhand how to solve it. In either situation, having a conversation with an employee in the context of the interactive process will hopefully give both parties an opportunity to brainstorm all possible ideas that could potentially overcome the workplace barrier. Remember your shared goal of identifying an accommodation that allows the employee to perform the job effectively and be prepared to bring ideas to the table. Some examples of possible accommodations include more frequent breaks from work, scheduling changes, leave for medical appointments or to recuperate, amplified telephones, standing desks, non-fluorescent lighting, and written rather than verbal instructions. Let's take a moment more to talk about leave as an accommodation because the Bureau has seen cases where some employers do not realize that leave can be an accommodation for a disability. In certain contexts, it seems intuitive. For example, if someone has cancer and needs extended leave to get treatment. But what if you have an employee who, like in the earlier example, just keeps calling out sick day after day, telling you they have something as uncertain as gut issues, and is going to the doctor for it periodically? As mentioned previously, in that scenario, the Bureau took the employee's notice to the employer of the medical condition and calling out sick as a request for an accommodation, while the employer, in the moment it was happening, was just looking at it as an employee using sick time and refusing to come back to work. So in light of this example, just remember that in the face of uncertainty, you are almost always going to be better off in engaging in the interactive process with an employee. Engaging in that process will allow you as an employer the opportunity to get additional information, even medical documentation, that you need to make an appropriate and informed decision regarding the situation at hand. In this particular example, the employer not only denied knowing that the employee had medical issues, it also acknowledged that it did not know that leave was an option as an accommodation for a disability. Now keep in mind that if you allow an employee leave as reasonable accommodation, you cannot penalize the employee for taking leave, such as it affecting performance reviews, raises, or discipline after the employee incurs a certain number of absences. Also, an employer should allow an employee taking leave as an accommodation to use accrued leave time, and then if that is exhausted, the employee can begin taking unpaid leave. And if you reach a roadblock or need assistance in identifying options for accommodations, reach out to Jan for help. As a last resort, when an employee cannot perform the essential functions of his or her current position with or without reasonable accommodation, an employer must look at whether or not the employee can be reassigned to another position. The position must be vacant at the time the accommodations are being considered, or vacant within a reasonable time, which is determined on a case-by-case basis. Also, the employee must be qualified for the new position. An employer does not have to throw an accountant into an attorney position, for example. So while the employee being considered for reassignment must be able to satisfy the required skills, education, and experience needed for the new position, and be able to perform the essential functions of the job with or without a reasonable accommodation, the employee does not have to be the best or most qualified person for the position in order to get the position as a reassignment. With that being said, an employer does not have to train up the employee for the position to make them qualified either. But the employee is entitled to the same type of training for the position that any other successful candidate would have received. The reassignment must be to a vacant position that is equivalent in pay, status, and benefits to the previous position. If there is no equivalent position vacant, the employer must reassign the employee to a vacant lower level position for which he or she is qualified. If there is more than one vacancy available that the employee is qualified for, the employer must place the employee in the position that is the closest to the employee's current position in terms of pay, status, and benefits. Reassignment does not include a position that would be considered a promotion. So through the interactive process, you have identified and agreed upon with the employee what accommodation will effectively help the employee overcome the workplace barrier experienced due to disability. Now is the time for action. In a timely manner, the chosen accommodation should be implemented and put into place. Remember that an employer is not obligated to provide the accommodation that the employee requested or wants. The employer is only required to provide an effective accommodation. Of course, an employer should consider the employee's preference. However, if there is more than one accommodation that would be effective, the employer can choose the least burdensome or most cost-effective choice. The EEOC guidance on the subject states that if more than one accommodation is effective, the preference of the individual with the disability should be given primary consideration. However, the employer providing the accommodation has the ultimate discretion to choose between effective accommodations. Once the agreed upon accommodation is implemented, the work is not over. An employer's duty to provide reasonable accommodation is an ongoing one. Best practice would be for an employer to be proactive, setting up some type of system for monitoring or checking in with the employee in order to evaluate the effectiveness of the accommodation. Remember that an employee's disability can change over time, necessitating a change in accommodation. If an employer discovers that an accommodation is not working out, or the employee informs the employer that the accommodation is ineffective, the requirement to engage in the interactive process resumes. Work together again to identify a new effective accommodation. Also, an employee may need more than one accommodation for a disability. There is no limit to the number of accommodations. However, an employee is only entitled to those accommodations that are necessitated by a disability and that will provide an equal employment opportunity. If you're looking for the ultimate defense to a failure to accommodate complaint, all you have to be able to show is that you participated in good faith in the interactive process. From that engagement, you will either have provided an effective and reasonable accommodation or determined that there was no effective reasonable accommodation possible. Again, the effective accommodation provided does not have to be the one requested by the employee. If you get into an interactive process and the employee is not participating or providing necessary and relevant information, You can put the interactive process on hold until you get that information. If that is the case, make sure you document what it is you're doing and why, including informing the employee so that he or she has an opportunity to provide the necessary and reasonable documentation requested. Finally, employers are never required to provide accommodations that present an undue burden or hardship. It's called a reasonable accommodation, not an unreasonable accommodation. So if something is unduly burdensome or fundamentally alters the way you do business, you do not have to provide it. The factors to consider when evaluating whether or not an accommodation is an undue hardship include the nature and cost of the accommodation, and the overall financial resources of the location making the accommodation, including the number of persons employed at the location and the effect on expenses at the location. If the business has multiple locations and is part of a larger entity, the employer must also assess the overall financial resources of the company and not just the location at issue. The type of operation of the employer and the impact the accommodation would have on operations is also a consideration. The Americans with Disabilities Act legislative history shows that Congress wanted employers to consider all possible sources of outside funding when assessing whether a particular accommodation would be too costly. Also, undue hardship is determined based on the net cost to the employer, so the availability of outside funding like state rehabilitation agencies or eligibility for tax credits to offset the cost of the accommodation should be taken into account as well. Furthermore, an employer should ask the employee with a disability if they are willing to pay for a portion of the accommodation, if a portion of the cost is too burdensome to the employer. The employee should be given the opportunity to pay the difference in those circumstances. When an employer is considering whether an accommodation poses an undue hardship, it should calculate the costs and preserve the information used in order to reach a determination. If an accommodation would be unduly disruptive to coworkers' ability to work, such a situation could constitute an undue hardship. As an example, the Bureau had a case with a charging party with a mental impairment who requested that any time management needed to speak with her at work, that a coworker attend the conversation. Since there were only 4 coworkers, having to pull someone away from their work at any moment's notice would have been an undue hardship. However, the possible lowering of coworkers' morale cannot be an undue hardship. For example, if an accommodation includes the reallocation of marginal functions to a coworker, the fact that the coworker is unhappy about the extra work but is still able to perform their own essential functions effectively is not enough to constitute a disruption to operations and undue hardship. Remember, it may be easy to accommodate your stellar employees. It can present a challenge to accommodate a more difficult employee. And yet, your legal obligations are the exact same. Regarding stellar versus challenging employees, be aware that performance is always on the table. A request for a reasonable accommodation does not require an employer to tolerate or excuse poor performance, withhold disciplinary action warranted by poor performance, raise a performance rating, or alter a performance evaluation that does not reflect the employee's actual performance. It is not reasonable to lower or change performance standards at work, assuming the performance standards are measuring the essential functions of the job and not marginal functions. An employer is never required to excuse past misconduct, even if it is the result of the individual's disability. If an employee with a disability violates a conduct rule or policy, the employer can still discipline the employee for engaging in the misconduct if the employer would impose the same discipline on an employee without a disability. So what should you do if you're in the middle of issuing an employee discipline for being tardy repeatedly and the employee discloses that the reason he is tardy is because he's taking new medication with the side effect of making him extremely groggy in the morning? If an employee asks for accommodation in response to a reprimand, counseling, or a poor performance evaluation, the employer can finish the discussion regarding the performance issues and issue the discipline. The employer can also use that time as an opportunity to begin the interactive process by discussing how the disability is impacting the performance and what accommodations the employee sees as necessary. If you choose not to engage in the interactive process at that time, don't forget to set up a time, in a reasonable time frame, to revisit that topic and begin the interactive process. Remember to take into account the severity of the barrier the employee is experiencing when determining what is a reasonable time frame to get the interactive process started and an effective accommodation in place. There have been accommodations cases at the Bureau where the cause finding hinged on the employer's delay in engaging in the interactive process or implementing an accommodation. Remember, not only is delaying a sign of bad faith, but also justice delayed can be justice denied. Because of confidentiality issues under disability discrimination laws, an employer must be careful with the types of questions it asks an employee regarding disability. So an examination of permissible questions when dealing with performance issues is necessary. If an employer knows or has reason to know that an employee is experiencing workplace problems because of a medical condition, and the employer knows that the condition prevents the employee from requesting an accommodation, the employer has a duty to ask the employee if he or she needs an accommodation. As mentioned earlier, circumstances that would impose this obligation on the employer include if an employer knows that an employee falls into a coma, or if the employee experiences a cognitive disability that makes them unaware of their rights to ask for an accommodation. On the other hand, the employer is allowed to ask, but is not duty-bound to ask if an accommodation is needed if the employer knows an employee has a disability that may necessitate an accommodation. For example, if an employer knows that an employee experiences major depression and reasonably believes that the disability is impacting the employee's work product, the employer can inquire with the employee if they need an accommodation. As another example, if an employer is scheduling an off-site meeting and has concerns whether the meeting location will be accessible for his employee in a wheelchair, the employer can ask the employee about possible accommodations for the meeting. It can all get rather confusing trying to determine when you can and cannot ask your employees about disabilities or impairments, but know this, you can always talk to your employees about how they are doing generally. If you see someone that's having a rough go, you don't really need to talk about impairments or disabilities. You can talk about what he or she needs to be successful. That type of conversation may well trigger a broader conversation, a conversation about reasonable accommodations, or maybe the person has no clue that their performance has deteriorated. So again, you can always ask your employees if they need anything to be successful. So in conclusion, here are some pro tips for employers that are applicable to any type of anti-discrimination law in the area of employment. First and foremost, having clear and effective policies is paramount. The difference between a good employer and a bad employer is not that good employers do not have discrimination complaints lodged against them, but rather, good employers have a process in place and will investigate and deal promptly, thoroughly, and fairly with complaints. Having quality anti-discrimination policies that specifically address discrimination based on all protected classes, reasonable accommodations, maternity leave, harassment, and retaliation is key. Post your policies. Make sure you get them in front of your management team and employees periodically to do reviews and make them accessible. Train your management and employees on these policies. Make sure your employees understand that discrimination is taken seriously and that their actions expose your business. In order to make sure your employees understand their employer takes discrimination seriously, good behavior should be modeled from the top down. Some written policies outline a procedure to inform employees the different ways that complaints of discrimination and retaliation can be made. If your business does not have that in its written policy, make sure to establish a complaint procedure. Making sure that complaints are addressed properly is important as well. Employers must promptly investigate complaints and engage in the interactive process when necessary. Employers should be aware of retaliation issues and implement policies and procedures to ensure no retaliation takes place after an employee requests an accommodation, complains of discrimination, or participates in an investigation into discrimination. And last but certainly not least is document and understand your decisions. Remember, this may be the evidence you need to defend against a discrimination or retaliation complaint. Would you like to learn more about the Montana Human Rights Bureau or discrimination laws? Visit our website at www.montanadiscrimination.com or give us a call at 1-800-542-0807 or 406-444-2884.